I'm going to talk about the fact that you should seriously all look at the alternative of litigation over legislation. Because many of the ideas also that Professor Odell proposed are already possible under the existing text of the case of the acts and the directives that we have in Europe. And I want to talk to you about one particular case I'm very excited about for the simple reason that I'm heavily involved in it myself. I'm going to talk about online lending of e-books and European copyright law. First of all, I give you a very brief course in European copyright law just in one sheet. European copyright law is laid down in several European directives. You've heard some of them already mentioned earlier this afternoon. I just want to mention another three. There's the Computer Software Directive from 1991. There's the Rental and Lending Directive from 1992, which was slightly changed in 2006, but it's more or less the same thing. And in that directive, it is laid down that public libraries are exempted from the exclusive right, and that they have a right to lend physical copies to the public if they pay a remuneration. So that is in the law of most European countries after 1992. And then there is the Copyright Directive, which has turned out of something that we really did not expect it to be, but it almost harmonized everything in copyright. Up to the InfoPact decision, we thought it might be partly harmonization, but in fact it does harmonize everything. What you have to know about copyright is that we traditionally have a strong separation between the making available right, or a communication to the public right, which was about making information available on the spot, or over the air or online, on the one hand, and we had distribution of copies, which was exhausted after the first sale, which means they can sell it on. Knowing all this, it is in the end the Court of Justice of the European Union that decides. In the end, they decide. And it often takes years and years to get there. And am I frustrated? Yeah, I used to be frustrated because I had to litigate over the question whether private copying from an illegal source, the ACI Adam case, whether private copying from an illegal source is actually allowed or not. I do represent libraries and archives, but I also represent anti-piracy organizations such as Brian. But in this particular case, I represent the people who have to pay the private copying levy. We litigated for 10 years over the question whether they also had to pay for copying from illegal sources, and in the end, we won in April 2014. And guess what? The first client, ACA Adam, went bankrupt 2 months before the decision. What is that to illustrate? It is useless if you have to litigate for 10 years to get the principle clarified. But the CGEU is the place to go there, and it is possible to go there quicker. And if you want to know more about it, please read the report by Hugo Brady, 12 Things Everyone Should Know About the European Court of Justice. It's a great report. If you just Google this, you'll find it, and it really gives an interesting insight. I want to tell you a little, is there a glass of water available here? About the background of this particular case in the Netherlands. The Ministry of Education, Culture and Science was preparing a Library Act. We did not ever have an actual Library Act in the Netherlands, but in 2012 they were planning to make a real Library Act where all aspects of public libraries in the Netherlands would be covered. And in the course of preparing that act, they commissioned a report by the colleagues from the IVIR and of the SEO, some of them are present here, and they concluded in the summer of 2012 that online lending of e-books is not permissible under the EU copyright law, especially not under the EU Copyright Directive and the EU Lending and Rental Directive, unless the CGEU would turn out to be activist. But that was the possibility they were still considering, but their report was quite clear. At the very same time, that very summer, the Court of Justice decided the Used Soft case. And that was a sensation among copyright lawyers, because for the first time the CGEU said that actually the right to sell digital copies could include the so-called exhaustion principle, or the principle of first sale, that you could actually resell a copy of a computer program if you've sold it, if you bought it online. That was really a sensation, and ever since that moment, people have been discussing whether that also applies to e-books, to music, to movies, anything. So that happened more or less at the same time, and that was happening. And just after that, two things happened in 2013, the beginning of 2013. The Ministry of Education, Culture and Science decided that there would be no statutory license for online lending of e-books included in this new Library Act. And that was no surprise, because they got this advice from the SEO EVA report, which says you cannot do it. It's against the directive. And that is something that I would like to ask Professor Odell to comment on as well. They were just afraid to do it. Because if they would get it wrong, they would be liable. If a national government does something that's not allowed by the European directive, and they do it on purpose, and they do it very expressly, then they get a claim, a so-called Frankovic claim. In the Netherlands, the Dutch government learned this the hard way, because they froze the private copying levy at a very low level for a few years, and now they have a 200 million euro claim from the right owners. So they have learned that it is very risky to try to push the barriers, because you just don't know what's going to happen. Because a member state cannot go to the European Court of Justice and say, well, we were planning to do this, is this okay? It's just not possible. That route does not exist. So at that exact moment, my client, the Dutch Library of the Dutch Association of Public Libraries, decided to start legal proceedings against the Stichting Leenrecht, who is a collecting society for the lending right, to get the issue decided by the Court of Justice of the European Union. At the very moment we started, we said to the Publishers Association and some of the collecting societies, please join the proceedings. Give your view, because we want a balanced a report here, and we want to have the case to go to the European Court of Justice as soon as possible. We do not want to wait for 10 years. We want to go there straight away. And we also drafted our claim very specifically. We said what we want is limited to e-books of novels, storybooks, biographies, travel stories, children's books and youth literature. Why did we do that, ladies and gentlemen? Please tell me. Sorry? Yeah, exclude academic publishing, but also exclude movies, exclude music, exclude games, exclude computer software. Just focus on what libraries are for. Because obviously what we want here is the court to decide that libraries can do what they've always done, which relates to traditional stuff you want to read. We also limit it to one copy, one user, because we want to resemble the old situation as much as possible. We also said that it would have to be based on a copy brought on the market with permission of the right owner, that we're not going to lend illegal copies. And we stressed the fact that we were willing to pay an equitable remuneration. Those were the conditions that we mentioned in the case. Well, what happened is that the Stichting Leenrecht, the collecting society, took a neutral position, which is quite understandable because their background is both publishers and authors, so they didn't know what to decide. In fact, they decided not to take a position at all. So they didn't decide anything. In fact, that's quite understandable. Picture Right for the visual artists and Lira for the authors, they take an ambivalent position. They really don't know, because they are very afraid that they would lose money if things like Tom Cabinet would also be allowed. But at the same time, of course, they think that they might get more money, namely 50% of the lending revenues, if they would get it through the collecting societies. So they take an ambivalent position. It's not quite clear what they're going to do. Now, the publishers are strongly against. They're so strongly against that they were even against referring questions to the Court of Justice, which was very funny because the court asked, would you prefer us to not refer questions even if it would mean that you would lose otherwise? And they said, yes, we would prefer that. We would rather lose than have questions. And then, of course, I asked, shouted through the courtroom, and would you then not appeal the decision? Well, yes, they would. Well, obviously they would, and then we would have to go to the Court of Appeals and to the Supreme Court of the Netherlands, and then ultimately we would have to go to the CJEU anyway, so it would take another 10 years. And that's why I was so excited. In fact, I'm still very excited. Adrenaline is still rushing through my body when last Wednesday the Hague District Court, for the second time in history, decided to ask questions to the CJEU at this low level of the district court. Because very often Supreme Courts refer these questions, but the lower courts are allowed to do it. And they should do it more often in cases like these. The court said it's not acte clair, the French word. It's not clear from the law. The law is not clear on this issue. And it has not been decided by the court yet. There's no acte éclairé. In fact, I say that it is an acte obscuré by the used soft decision, but that's not the legal term. The facts of the case are quite clear. Both parties could give all their arguments, and questions have to be referred to the CGEU. So that is really great news. Especially for me, obviously, because I'm allowed to go to the exciting city of Luxembourg again. But it is great that we can now, probably in 3 years, I think the beginning optimistic view would be that we have a hearing around this time next year, and that we would have a decision early 2016. That would be well within 3 years we could get a very important decision here. What are the exact questions that the district court proposed to pose to the court? Does lending in the EU directive also cover online lending of e-books? Again, limited to those categories. One copy, you don't have to make a photograph of that because I can send you the decision and I will send it to anyone who wants to have it. But you can make as many copies as you want, photographs as you want, obviously. If so, does it have to be based on a digital copy put on the market by the rights owner? If not, are there any other requirements? For instance, that it is a legal copy. I can't quite imagine what the difference is, because a legal copy probably supposes a copy that was brought on the market by the right owner, but I don't mind them putting that extra question. And if so, of course, if so, can it be put on the market by downloading? And of course, this is the Tom Cabinet question, the last one. That's the explosive one. But the thing is, I wish Tom Cabinet all the best luck and all luck in the world, but it's very tricky what they're doing. Because they cannot prove that people who upload stuff actually delete it, and they cannot therefore ensure that it is just an unlimited extra number of copies being sold over their network. Still, I think they're very courageous, and I want them to succeed, but this option is much safer, because this step is so sympathetic that I am convinced that we can win this. And then, of course, the next step would be to expand on all the categories. And that we could move on. But this is really a great example of how you could do something through litigation. And you've all been talking about trying to change the law through legislation. But the national legislators are afraid to do so because of the risks of liability. And many of the ideas that were suggested by Professor Odell can be tried within the existing text of the law. If you look at Article 13 of the Dutch copyright law, you can already read in there that if you make an innovative new copy, then it would in fact no longer be an infringement. That's not what we traditionally held in case law, but you could read it inside that. Having a text of 160 words together with a link is something that the Court of Appeal of Arnhem already allowed in the Zoek alle Huizen case. So we already done it within the citation law. We can do so much by litigation. So therefore, not only look at legislators, you should keep on trying to influence legislators, but also invest in litigators, because litigators can make changes very quickly. The Court of Justice is in fact very progressive in these kind of things. You can see that in the Premier League decision about the resale of smart cards. All those guys are old, and they don't know that much about internet. But they all have children. And in fact, the Advocate General, the Finnish Advocate General, told one of my colleagues that whenever he has an issue on intellectual property, and the internet, for instance, was about the AdWords case, the Google AdWords case, he goes to his son, which usually is between 20 or 30. If you're 60, and very often your son or daughter is between 20 and 30. They are very progressive, so they reflect very progressive thoughts, and the CGEU can make many changes if we can get there quickly, and we're going to do it in this case, and it's all going to be great, and we're going to solve everything in this way.
So aim at the children is what you should do if you lobby it. I think there was a direct question to you along the way.
Well, my direct question would that be a possible explanation for the ministry responsible in Ireland to be hesitant to do things because if they get it wrong, they might be liable?
Yes, the report for the new minister said that the matter is still being considered by the Attorney General, and our Attorney General's office is extremely risk averse and litigation averse. So that may be one of the reasons. When you pointed out the potential for Frankovich liability, I was trying to think how there might be Frankovich liability in respect of an exception, especially if the exception is a non-commercial exception where there are no commercial consequences. A lot of the things that would be allowed by fair use wouldn't generate a Frankovich liability anyway.
Well, I'm not so sure, because, for instance, in the Netherlands you see now developments where archives have to pay a lot of money to collecting societies, especially visual rights, like 10,000 euros per year to have the photographs on the website of the archive. Mm-hmm. Obviously that income would go away if it would be said that an exception would apply in such a situation. So the collecting societies would lose out on not getting any remuneration from the archives anymore. So there is a risk.
Except that example is already allowed within the InfoSoc directive. You could get very close to that very easily on the basis of the InfoSoc directive. And if it got litigated, then of course you'd be very happy, because I don't litigate, so I'm not going to advocate that courts are always the right solution. But the CJEU is getting there, and I'm reasonably confident that if they got a case along the lines of can we go this far as we were suggesting in our various exceptions, that they would probably say yes. But the Attorney General, on the other hand, her job is to be careful and risk averse, and she is. So I think that that's a possibility, certainly.
Yeah. No, I'm of course not suggesting that litigation is a complete alternative. Of course, legislation is better, even especially in the long way. But you can get quite some things done through litigation as well. It's not that complicated, and especially in an organization like what's it called? Copyright for Creativity, or Creativity for Copyright. You can organize people, and please, of course, ask all your national governments to intervene in this case, to say that is a good idea, because until the summer of 2012, nobody dared think that e-lending would be covered by these statutory licenses. And after Usoft, it turns out to be possible. So think out of the box and force your own government to intervene in these proceedings to say that it's a good idea to allow libraries to do e-lending under the statutory license.
Thank you very much. Don't limit yourself. Think out of the box. Those are the two sentences I heard you say. Thank